Hello everyone. Since we discussed the company law topic last time, I shared a video. So there are certain topics which are very much important if you are into the topic of core company law. Certain doctrines which add a relevance to our topic of company law. Let's discuss one of that doctrine, that is Doctrine of Ultra Vires. Let's study the legal scope and consequences of that. To begin with, the principle of absolute nullity. At its core, the doctrine mandates that it's compulsory that any corporate action or agreement exceeding the authority granted in Memorandum of Association object clause is legally non-existent. That is, it's void ab initio, which stands for which is not valid from the very beginning. Because these acts fall outside the company's legal capacity and they are entirely null and cannot be legalized through subsequent ratification, even if the shareholder provides their unanimous consent for the same. So, what exactly the Doctrine of Ultra Vires states that? Which states that when it's beyond the power of Memorandum of Association, certain clauses which are beyond the power of Memorandum of Association, they are considered as void ab initio. Further, why this doctrine is being established? Since a corporation is purely artificial legal entity, we know that a corporate is an artificial entity and it's being run by the people involved in it. So, without on its own discernment, the doctrine of ultra vires serve as a vital protective mechanism for shareholders and creditors. It's basically the safest mechanism for the people like you and me who rely on the company. It acts as a restrictive barrier since the powers are mentioned in they can't go beyond the MOA, which are already stated. One can easily go through the MOA from ROC, which is being registered over there, ensuring that the corporate capital provided by investor and relied upon by the lenders is never diverted into unauthorized or speculative ventures not sanctioned in the MOA. So this doctrine clearly states that all the powers which are mentioned in MOA need to be adhered by the corporates of a company, by the members of the company, stakeholders, shareholders of the company. So they cannot deviate from that power, they cannot deviate from that clauses, and organization should be run on the basis of those clauses only. Then managerial oversight and due diligence. The primary burden of ensuring compliance rests with the company's leadership. Obviously, we all know that they are the actual, we can say that karta dharta of the organization, right? Directors and officers have a fiduciary duty which is based on the basis of trust, basically a relation, because we are stress free because we know that directors are working in the organization and we believe that they work in the benefit of the company. So there we hold a fiduciary relation with the company, and these directors and officers have a fiduciary duty to confirm that all the corporate activities remain strictly within the boundaries of the object clause. So, what this doctrine states that before finalizing significant agreements, management must verify that proposed transactions are intra vires and not the ultra vires, where intra vires stands for within the company's power. That is a director, officer, or a company's head cannot work beyond the powers of MOA. When engaging with other corporations, since they deal with other corporations, it is equally essential to scrutinize the counterparty's MOA. This prevents the other company from later repudiating their contractual duties by claiming the agreement goes beyond their legal duty. So this doctrine holds a very much significance in the working of a company, since companies work as per the guidelines stated and as per the rules framed in MOA. So it's the duty of every company to do diligently follow the clauses, the system mentioned in the MOA. Then if I talk about liability and legal implications, directors accountability, directors are personally liable to the company for losses incurred through ultra vires. That is, no director can work beyond the power of company, that is ultra vires. However, a third party can only hold directors personally responsible if they misrepresented their authority. That is, if a breach of authority is being found, then only directors are accountable. But if directors are following MOA as per the rules and regulations stated, then there is no case of ultra vires in that, provided that unless and until any kind of misrepresentation is found on behalf of directors. Contractual limitations: if an outsider enters into a contract that clearly contradicts the company's public powers, they have no legal standing to sue the company or its directors. Property and loans: the law treats a company in trust in ultra vires. Property or lending, similar to the protection of the afforded to the minors under the Indian Contract Act. So this, like a way a minor is being protected, an Indian Companies Act, sorry, Indian Contract Act, let me correct it. That's an Indian, similar way, companies and trusts are protected as per the clause of Doctrine of Ultra Vires. Doctrine of Ultra Vires is very much beneficial for the creditors, shareholders, and the stakeholders of the company. If a company lends money via contract that is ultra vires, it's MOA, it may legally barred from suing to recover the debt as the transaction is technically void from the start. So this is all about Doctrine of Ultra Vires, its legal scope and consequences. We studied the legal scope over here and the consequences one can bear if such acts has been act has been found beyond the powers of the company, that is ultra vires, and beyond what is written in the MOA. Thank you. And I have very much cleared about void ab initio, and there is no rectification for ultra vires. It's totally the liability of the directors to follow the what is written in MOA, and it's meant, this doctrine is basically meant for shareholders and creditors protection. Thank you. And I hope further lectures will also clear two or more, three such type of doctrines, like doctrine of constructive notice, doctrine of indoor management. So do follow and subscribe for the further doctrines and the topics which are necessary for understanding the company law in an effective manner. Thank you.